Fashion modeling law in 2025, France, the UK, and the US, New York City, and Los Angeles. Welcome to Crefovi's live webinar. My name is Annabelle Gauberti. I am a solicitor of England of Wales and an advocate at the Paris Bar, and the founding and managing partner of Crefovi, the law firm for the creative industries. Today's session is dedicated to a subject that combines glamour, business, and legal complexity, fashion modeling law in 2025. We will explore how the law regulates the modeling profession in France, in the United Kingdom, and in the United States, with a particular focus on New York and Los Angeles. Here's our roadmap for the next half hour. We will begin with the origins of modeling law and how modeling became a profession. We'll then review the employment status of models today in each jurisdiction. We'll turn to collective frameworks and unions, then compare the tax regimes. We'll analyze how image rights are treated across France, the UK, and the US. And finally, we'll look at contracts and the disruptive impact of artificial intelligence on the modeling business. Let's dive in. The origins of modeling law. Modeling began in Paris long before agencies existed. In the late 19th and early 20th century, couture houses like Worth, Paquin, Poiret, Chanel, and Schiaparelli employed their own mannequins de maison. These women presented garments to clients in salons, posed for photographers, and even appeared in images filed with the French Intellectual Property Office for copyright and design protection, INPI. From the 1920s onwards, external agencies emerged. First in New York, John Robert Powers founded the first professional modeling agency in 1923, followed by Walter Thornton in 1930, Harry Canova in 1939, and then Ford Models in 1946, launched by Eileen Ford. In London, Lucy Clayton opened an agency and modeling school as early as 1928, with Models 1 arriving in London in 1968. Paris came later. Only in the late 1950s did Dorian Lee and Catherine Harley set up agencies, followed by Elite in 1972, Elite Management, founded by the father of Julian Casablancas from The Strokes, Mr. Casablancas Sr. So within a few decades, modeling transformed from in-house promotion to a professionalized global industry. What is the employment status today? In France, the law presumes that any modeling work is salaried employment, regardless of labels like freelance or service provider. Courts, URSSAF, and inspectors systematically requalify modeling contracts as employment. Agencies are the legal employers. They issue contracts, pay wages, and handle social contributions. The brand or end user signs a contrat de mise à disposition with the agency and can even be held liable if the agency defaults. By law, all this must be in writing. In the United Kingdom, most models are treated as self-employed. They invoice clients, pay their own income tax and national insurance, and agencies charge commissions, usually 20 to 35%. The Conduct of Employment Agencies Regulations 2003 require written terms and transparency, but there is no collective bargaining agreement. Equity, the performers' union, runs a models network offering advocacy and template contracts, but ultimately, protection depends on contract negotiation. In the US, there is no single nationwide status Most models are independent contractors. On-camera commercial work may fall under SAG-AFTRA collective agreements, which bring in union session fees, residual payments, and health and pension contributions. But print and runaway work are outside SAG-AFTRA. New York has led reform. Since June 2025, the Fashion Workers Act requires recent contracts, payment deadlines, capped commissions, and consent for AI, artificial intelligence replicas. California applies the ABC test for worker classification, but offers no modeling-specific protections. What about collective frameworks and unions? Well, in France, it has a dense framework. The Convention collective nationale des mannequins, IDCC 2397, covers models under 16 and adults, with rules on minimum pay percentages, categories of work, and safeguards for minors. A new agreement signed in March 2025 updated wage minima and clarified procedures, though it stopped short of granting models intermittent du spectacle status. On the institutional side, SINAM, born from the merger of SAM and UNAM, represents agencies, while the Fédération Française des Agences de Mannequins maintains industry standards. The result? A protective but fragmented system. In the UK, there is no model-specific collective bargaining agreement. Equity fills the gap, but representation is modest. On the industry side, the British Fashion Model Agents Association represents agencies, not models. Compared to France, the UK is light touch and flexible, but offers weaker formal protection. The United States, here we find a desert. There is no national union or collective bargaining agreement for models. The Model Alliance, founded in 2012 by Sarah Zief, has achieved important legislative reforms, including the 2013 Child Model Law in New York and the 2025 Fashion Workers Act. But it is not a union and bargaining power remains limited. Let's have a look at some tax snapshots, shall we? In France, models employed via agencies see heavy social charges. A 1,000 euros day rate nets around 750 euros before income tax. Post-shoot exploitation payments and Article L 7123-6 of the French Labour Code, to be exact, are treated as non-salary income, often as bénéfices non commerciaux, BNC, with CSG and CRDS applied, which are the French social security charges. Foreign models often complain they pay into URSSAF without benefiting from French welfare, obviously because they live abroad. In the United Kingdom, self-employed models pay income tax at 20, 40, and 45% bands, plus Class 4 national insurance contributions. Crucially, they can deduct business expenses, travel, accommodation, portfolio, agency commissions, making the UK regime flexible and often more tax efficient than France. In the United States, well, US models pay on 1099 basis, face federal progressive tax plus a 15.3% self-employment tax. So on a $200,000 income, a model may pay around $37,000 of federal income tax, $23,000 of self-employment tax, and up to $22,000 of state and city tax in New York. The ability to deduct ordinary and necessary business expenses is the main relief. Now let's turn our attention to image rights. In France, image rights are anchored in Article 9 of the Code Civil and Article 8 of the European Convention for Human Rights. Courts require express, specific, and remunerated consent for use of a model's image. There is no such thing as royalty-free in French law. Retouched photos must carry label photographie retouchée. Enforcement is uneven, but the principle is strong. In the United Kingdom, there is no standalone image rights. Models rely on privacy law and passing off. Naomi Campbell versus MGM Limited established privacy protections. Rihanna versus Topshop showed that passing off can apply to false endorsements. But litigation is costly and protection is piecemeal. In the United States, models rely on state right of publicity laws. California's civil code protects against unauthorized commercial use of name and likeness, even post-mortem. New York added paragraph 50F in 2021 in its legislation covering digital replicas. Other states vary widely. Enforcement requires clear contracts and often litigation. Contracts and the AI challenge. With respect to agency agreements, well, in France, agency contracts are employment agreements. In the UK, there are self-employed contracts with commissions and long-tail clauses. In the US, the mother agency system ties models to a first agency, with commission sharing across markets. The second type of contracts is a contract with clients, so client agreements. The most important clauses are license terms, media, territory, and duration. Other broad licenses, like all media in perpetuity throughout the universe, are red flags. Exclusivity and morality clauses must be narrowly drawn and fairly paid. Health and safety provisions and payment deadlines are vital. Now, moving on to artificial intelligence and digital replicas. This is a frontier. In August 2025, Guess fronted an entirely AI-generated model and campaign. The EU AI Act now requires disclosure of synthetic content. New York and California have adopted protections against unauthorized digital replicas. Contracts must explicitly prohibit AI training and require separate consent and compensation for replicas. Without those safeguards, models risk losing control of a likeness to endless digital exploitation. To sum up, in France, the framework is protective but heavy and inconsistent. In the UK, the framework is flexible but offers limited rights. In the US, protection is patchy at best, with New York and California leading reform. Across all three jurisdictions, the rise of AI makes clear, precise contracts more important than ever. So models need to lawyer up and have good legal advice when joining agencies, when signing contracts, and deciding what to do in terms of potentially licensing off their image rights through the content generated by AI. Thank you for joining me today. I hope this webinar has clarified the evolving landscape of fashion modeling law in 2025. The replay will be available shortly, and if you'd like to discuss any of these points further, please don't hesitate to reach out to me at Crefovi. Do follow us on social media, Twitter, X, LinkedIn, and Instagram. And it's been a pleasure. Bye for now.